My cousin Brenda called me on a Saturday morning and told me that the house had been transferred into a trust. She said it like it was already settled, in the specific tone people use when they have prepared the information in advance and want to deliver it as a conclusion rather than a discussion. She said our Aunt Vera had established a revocable living trust 2 years before she died, and that the house in Kettering was now in the trust and would be distributed according to the trust document, and that I should know this, so I was not surprised when the estate was administered. She said Vera had wanted it this way and that the trust had been prepared by an attorney and everything was done correctly, and the house would be going to Brenda because Brenda had been the one who was there for Vera in the last years, and Vera had wanted to acknowledge that. I said I would like to see the trust I want to describe the specific quality of Brenda's call, and what the particular phrasing she used told me about what she expected my response to be. She said the house has been transferred into a trust in the same tone that someone uses when they have prepared the statement and rehearsed its delivery, and believe that the delivery will settle the matter. She said trust and recorded an attorney in the same sentence as if the presence of those words made the claim more authoritative than the claim itself. I am a paralegal. I have spent 16 years working with the documents those words describe. I understand what a trust is and what a deed is and what recorded means. And I understood immediately that the claim had a specific testable element. If the house was in the trust, there was a deed. If there was a deed, it was in the Montgomery County Recorder's index. I said I would like to see the deed. She said trusts are private. I said the deed is not. She said her attorney would be in touch. I did not wait for her attorney. I searched the recorder's portal. The deed was not there. I knew what that meant. I called Marcus and then I called Cornelius, and then the case was underway before Brenda's attorney had sent the first letter. I also want to say something about the specific way that Brenda presented the claim and what it revealed about what she had anticipated my response to be. She had expected, I think, that the mention of a trust and an attorney and a proper legal process would be sufficient to close the conversation before it really opened. She had expected that I would accept the claim without examining its mechanism because most people who have not worked with property records do not know that the mechanism is public and verifiable in about 15 minutes. She did not know I was a paralegal, or she had forgotten, or she had hoped it would not matter. It mattered. The first question I asked was about the deed, and she did not know what to do with the question because she had not prepared an answer that would survive scrutiny. She deflected to the privacy of the trust document. I did not argue. I searched the public record instead. The public record does not deflect. The public record answers. It answered. Document. She said it was a private document and trusts were not public record and she was not required to share it. She was correct that trusts are not public record. I said I understood. I asked when the house had been transferred into the trust. She said 2 years before Vera died. I said I would like to see the deed transferring the house into the trust. She said the same thing, that it was private, that she was not required to share it. I said the deed would be recorded with the county recorder and would be public record regardless of whether the trust document was. She did not respond to this directly. She said she would have her attorney be in touch. I went to the Montgomery County Recorder's website. The house in Kettering had been in our family for 41 years. My Aunt Vera had purchased it in 1983 with her late husband Harold, and after Harold died in 2009, she had owned it alone. The house was a brick ranch on the east side of Kettering, in the part of the city where the houses are well maintained and the yards are kept and the neighbors have been in the same houses for decades. Vera had been in that house for 41 years, and the house had the specific character of a house that a person has occupied and tended for 41 years, which is the character of a house that has been shaped by a single continuous presence. I want to explain how real property enters a living trust in Ohio in more detail because I think the gap between how people believe trusts work and how they actually work is significant, and is the gap that made this claim initially plausible to members of the family who are not lawyers or paralegals. When people think about a living trust, they often think of it as a container. You put your assets in the container when you create the trust, and the container holds them and distributes them according to the trust document when you die. This is a reasonable intuitive model, and it is partially correct for financial assets like bank accounts and investment accounts, which can be titled directly into a trust or designated to transfer to a trust on death. But for real property in Ohio, the trust document is not the container. It is the instruction manual for the container. The container itself is the deed. You execute a deed that says, I, Vera, as an individual, convey this property to Vera as trustee of the Vera Living Trust. You sign it. You have it notarized. You record it with the county recorder. Only then is the property in the trust. The trust document alone does nothing to the title to real property. You need the deed. If the deed is not in the recorder's index, the property was not moved. Full stop. Ohio law is clear. The recorder's index confirms it. The deed was not there. The property was not in the trust. I want to add one more element to this explanation because I think it is the part that most often surprises people. When an estate attorney prepares a living trust for a client who wants to put their house in it, the attorney typically prepares two documents simultaneously, the trust document itself and the deed that transfers the property into the trust. The two are prepared together because the deed is what makes the trust document operative with respect to the property. Cornelius had not prepared a trust for Vera. He had not prepared a deed. If someone else had prepared a trust document for Vera, the absence of the trust transfer deed in the recorder's index meant either that the attorney who prepared it had not completed the work, or that the trust document had been prepared without the accompanying deed that would have given it effect with respect to the real property. In either case, the result was the same: no deed, no transfer. Ohio law does not provide a remedy for incomplete legal work. The deed either exists in the recorder's index or it does not. It did not. My Aunt Vera was 81 when she died. She had been sharp and direct until very close to the end, the kind of person who says what she means and who does not expect you to guess. She had told me, at a family gathering 3 years before she died, that the house would go to her nieces and nephews equally, that she had discussed this with her estate attorney and the arrangement was in place and she wanted the family to know so there would be no confusion. She had said this at the table after dinner in the specific way she had of making statements that she wanted to be understood as final. I had noted it. She had 4 nieces and nephews. I was one of them. Brenda was one of them, the daughter of Vera's late brother. And Brenda and Vera had been close in the last years. And Brenda had done a great deal for Vera in her decline, and no one disputed this. The question was not whether Brenda had been there. The question was whether Vera had decided to change her stated intentions, and, if so, whether the change had been properly documented. I searched the Montgomery County Recorder's portal for the property address and for Vera's name. I found the deed history. I found the original purchase deed from 1983, showing Vera and Harold as grantees. I found subsequent instruments over the decades, Harold's death and the deed passing to Vera alone. I found no deed transferring the property into a trust. Not 2 years before Vera died. Not 1 year before. Not at any point in the recorder's index going back to 1983. There was no trust transfer deed. The absence was the evidence. In Ohio, I want to say something about what Vera understood about the difference between intention and documentation. She had been a registered nurse for 35 years, and nurses operate in environments where the difference between what you intended and what you documented is not a philosophical matter. It is a legal matter and sometimes a clinical matter, and the consequences of letting them diverge are real and traceable. A nurse who intended to administer a medication but did not document the administration has created a gap in the record that cannot be filled by explaining what was intended. A property owner who intended to transfer their house into a trust but did not execute and record the deed has created the same kind of gap. The intention is not the action. The documentation is what closes the gap. Vera had spent 35 years understanding this professionally. She applied it to her own affairs the same way she had applied it to her patients' records. Her will was documented. Her review letter from Cornelius was in the drawer. The drawer was findable. If she had established a trust, she would have confirmed with Cornelius and kept the relevant letter in the tab. The tab did not have a letter confirming a trust. It had a letter saying no trust had been established. The letter said what the deed index said. Both were right. I also want to say something about what Vera would have thought of a trust document that left everything to one person rather than equally to the 4. Vera had made her intentions clear at the dinner table 3 years before her death, and she had made them clear to Cornelius in the document she had him prepare, and in the review letter she had kept. She had been direct her entire life, and she had been direct in her estate planning. If she had wanted to change her intentions, she would have called Cornelius. She had not called Cornelius. She had asked for the review letter instead, 1 year before she died, confirming that everything was as it had been and as she wanted it. The letter said no trust. The drawer said the same thing the recorder said. The recorder said what the law said. Everything in the record pointed in the same direction. When every document in the record points in the same direction, that direction is the answer. It was the answer. When you transfer real property into a living trust, you execute a deed conveying the property from yourself as an individual to yourself as the trustee of the trust. This deed is recorded with the county recorder the same as any other deed. If Brenda was right and Vera had transferred the house into a trust 2 years before she died, that deed would be in the Montgomery County Recorder's records. It was not there. The house had not been transferred into a trust. Whatever trust document might exist, the house was not in it, because the deed that would have put the house in it had never been recorded. The county recorder did not lie. The county recorder did not have selective memory. The county recorder had every deed that had ever been filed for that property going back to 1983, and there was no trust transfer deed among them. Before I go on, if this story connects with something real in your life, please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Adaeze. I am 41 years old, and this is the story of how a missing deed, which is to say the complete absence of any instrument in the Montgomery County Recorder's records transferring my aunt's house into the trust Brenda claimed existed, and an estate attorney named Cornelius Webb who had known my Aunt Vera for 9 years, and the specific clarity of Ohio law about how real property gets into a trust, gave 4 nieces and nephews what Vera had said at the dinner table she intended for them. Now let me tell you about Vera and about the house and about what 41 years in the same place looks like when you find it intact after the person who lived it has died. Vera was my father's older sister. She and Harold had no children, and after Harold died, she had lived alone in the house with the specific self-sufficiency of someone who had spent her working life as a registered nurse and who applied the same organized attention to the management of her own home and health that she had applied to the management of her patients' care. She retired at 67 and continued into her late 70s to be the person in the family who knew what was happening to everyone and who kept the connections that large families depend on particular people to keep. She sent birthday cards. She called. She remembered what was important to people and asked about those things when she saw them. She was, in the specific sense that matters to a large family, the person who held things together. The house reflected this. It was organized in the way of someone who had spent a career in environments where organization was not optional and who had carried those habits home. Her kitchen was arranged with the logic of a person who understood workflow. Her files were in order. Her medical records were current and filed in a folder labeled with the year. Her legal documents were in a drawer in the bedroom that she had told me about specifically once during a conversation about what I should be able to find if something happened to her. She said the drawer has what you need and you will be able to find what is in the drawer. This was the kind of statement she made, direct and informative and designed to be remembered. I remembered it. When I went to the house after she died and opened the drawer, I found her will, signed and dated and witnessed 3 years before her death, her insurance policies, her financial account information, her advance directive, and, filed behind a tab labeled Estate Planning, a letter from her estate attorney, Cornelius Webb, dated 1 year before she died. Summarizing the status of her estate planning documents and confirming that her will was current and reflected her wishes and that she had not established any trust, and that her real property remained in her name individually and would pass through her estate according to her will. The letter from Cornelius had not been a letter confirming a trust. It had been a letter confirming the absence of a trust. It had been a review letter, the kind that estate attorneys send periodically to clients to confirm the current status of their documents. And it had said, "Your will remains current. You have not established a living trust. Your real property is titled in your name individually. If your circumstances or wishes change, please contact us." Vera had filed this letter under the estate planning tab. She had kept it where I could find it. She had always kept things where they could be found. I called Cornelius Webb the Monday after Brenda's call. His office was in Dayton, and he had been Vera's attorney for the last 9 years of her life. He answered his own phone, which is something that attorneys with small practices sometimes do, and he said Vera's name when I said it, and I could hear in how he said it that she had been a client he had genuinely liked. He said he had been following the estate situation and had been expecting a call. He said he had prepared her will. He said he had not prepared a trust. He said if a trust document existed, he had not written it, and he did not believe Vera had had another estate attorney. He said he would like to be retained to represent the estate in any challenge to the claimed trust distribution. I said I would be calling back within the day. I want to tell you about Vera's nursing career and what it meant in the context of the drawer in the bedroom. She had been a registered nurse at Kettering Health Network for 35 years, starting in the surgical unit and ending in the administrative nursing role she had occupied for the last 12 years of her working life. The administrative role had required her to be the person responsible for the documentation systems of her unit, for ensuring that the records were accurate and complete, and that the people who needed them could find them. She had brought this responsibility home with her the way that people bring the core habits of their professional lives home with them when those habits are deep enough. The drawer in the bedroom was organized with the logic of a record system that someone had thought about and tested and refined over time. Every folder was labeled. Every label was accurate. Every item in the folder was relevant to the folder's label. Nothing extraneous, nothing misplaced. She had told me where the drawer was because she was the kind of person who tells you where things are when the things are important, and when she wants to be sure that finding them does not depend on luck or extensive searching. The drawer was her version of a handoff to the next shift. She had been doing handoffs correctly for 35 years. She did the last one correctly too. I want to say one more thing about the drawer and about why I believe Vera had chosen to tell me where it was rather than one of the others. I am the paralegal in the family. She knew this. She had known since I started working in legal support in my mid-20s, and she had always paid attention to the work the people around her did and what their work meant they were capable of. She told me where the drawer was because she knew that if I found the drawer, I would know what to do with what was in it. She had matched the information to the person who could use it. 35 years of nursing had taught her that this is how you do a handoff. You give the relevant information to the person who can act on it. I found the drawer. I found the letter. I called Cornelius. The handoff worked exactly as she had designed it. I also called the other 3 nieces and nephews that Monday. They had each received a version of the same call from Brenda. None of them had been presented with the trust document. None of them had been given the deed that would have transferred the house into the trust. One of them, my cousin Marcus, had also searched the Montgomery County Recorder's portal and had found the same absence I had found. We retained Cornelius together. Cornelius filed a petition in. I want to say something about the role of the 4 of us acting together and about what collective action in an estate dispute requires and produces. We had each been given the same information, and each of us had independently done the same thing, which was to look at the public record. When we compared what we had found, which happened in a phone call that had the specific quality of 4 people who are all discovering they have come to the same conclusion from the same direction, we understood that the evidence was not ambiguous and that proceeding together was the correct approach. Retaining 1 attorney rather than 4 was economically sensible and legally coherent because our interests were identical: to establish that the house was part of the estate and to have it administered according to the will. Cornelius had known Vera and had prepared her documents and had the file and was the natural choice. We each contributed what we had found. I brought the recorder's search and the letter from the drawer. Marcus brought his own recorder's search, which confirmed mine. Denise brought documentation of Vera's stated intentions from a conversation she had had with Vera 3 years before her death. Tom brought the exchange with Brenda in which Brenda had refused to produce the deed. Cornelius assembled the whole picture and filed it. Together, it was compelling. It would have been less so in pieces. I also want to say something about Denise's contribution specifically. Denise had had a conversation with Vera 3 years before Vera died, in which Vera had said directly that she had no intention of changing her will, and that the 4 nieces and nephews would receive equal shares, as she had always planned. Denise had written this down in her journal because she is someone who writes things down, and the journal entry was dated. She brought the journal to Cornelius's office. He looked at it and said, "This is evidence of stated intention." He said it is not the central document, but it corroborates everything else. He said a dated journal entry documenting a conversation about testamentary intent carries weight because it was made at the time of the conversation and not in anticipation of the litigation. He said Denise had no reason to fabricate this entry, and the entry was consistent with everything else in the file. He included it. It supported the submission. It was one more thread in the same fabric. The fabric was strong. It held. Montgomery County Probate Court to administer the house as part of the estate under the will. He submitted the will, which left the real property to the 4 nieces and nephews equally. He submitted the letter he had sent to Vera 1 year before her death confirming the absence of any trust and that the real property remained in her name. He submitted the Montgomery County Recorder's complete deed history for the property, showing every instrument recorded since 1983 and the absence of any deed transferring the property into a trust. He submitted a sworn statement from himself as Vera's estate attorney. He submitted a statement from me describing the drawer in the bedroom and what it contained and the letter I had found. He submitted statements from all 4 nieces and nephews. Brenda's attorney filed a response presenting the trust document. It was a document called a Declaration of Trust, naming Vera as the trustor and Brenda as the successor trustee and sole beneficiary. The document was dated 14 months before Vera died. Cornelius reviewed it. He submitted a reply. He said the trust document was a piece of paper that described an arrangement. He said the house was a piece of real property in Ohio. He said in Ohio, real property does not enter a trust by virtue of a trust document existing. It enters a trust when a deed transferring it into the trust is executed and recorded with the county recorder. He said the trust document could be entirely authentic, could have been signed by Vera on the date it stated, and it would still not have transferred the house into the trust because the deed that would have accomplished the transfer was never executed and never recorded. He said the recorder's index did not show the deed because the deed did not exist. He said the house remained in Vera's individual name because it had never left Vera's individual name. He said the house would be administered as part of the estate under the will. He also noted in the reply that the trust document had not been drafted by him or by any attorney whose name appeared in Vera's file, and that the nature of the trust's terms, leaving everything to a single beneficiary at the expense of the other heirs named in the existing will, was a significant departure from the estate planning he had conducted with Vera, including the most recent review letter which had been sent 1 year before her death and which had made no mention of any trust or any change in Vera's wishes. The Montgomery County Probate Court, I want to tell you about the probate court process and about what it meant to have Judge Francine Adaeze assigned to the matter. Judge Adaeze had been handling probate matters in Montgomery County for 14 years and had the specific command of a judge who has seen every variation of contested estate claims that the Ohio Mahoning Valley and its surrounding counties produce and who understands the patterns. She reviewed the submissions before the first hearing in the specific way of a judge who reads before she asks questions and who arrives in the courtroom having already formed a view. Cornelius had told me she would want to see the deed history from the recorder and that she would understand immediately what the absence meant. He was right. She looked at the recorder's index entries and she asked Brenda's attorney where the trust transfer deed was, and the attorney said it had not been recorded. The judge said then the property was not in the trust. She said this as a statement of law rather than a conclusion of fact because it was a statement of law. She had been confirming Ohio property law in her courtroom for 14 years, and she knew it the way you know something you have applied correctly many times, and that has not yet been wrong. She confirmed it again. She ruled. The house was administered under the will. The 4 of us received what Vera had said at the dinner table we would receive. After the ruling, I sat with Cornelius in his office, and he said Judge Adaeze was one of the most efficient probate judges in the region, and that cases with clean records were resolved cleanly in her courtroom. He said the clean record in this case was the recorder's index. He said the index was a clean record because it had the complete history and the complete history had nothing where the trust transfer deed should have been. He said when the central fact is an absence, the cleaner the absence, the cleaner the case. He said an index that goes back to 1983 and shows 41 years of accurate and complete deed history with no trust transfer deed anywhere in it is about as clean an absence as he had encountered. He said Vera had given me everything I needed in the drawer. He said the recorder had given me everything else. He said between the 2 of them there was nothing left to establish. He said it was a well-organized case. I said Vera was a well-organized person. He said yes. He said I know. He said I worked with her for 9 years. I said I know. I said she told me where the drawer was. He said of course she did. Assigned the matter to Judge Francine Adaeze, who had been handling probate matters in Montgomery County for 14 years. She reviewed the submissions. She noted in her ruling that the question of whether the trust document was authentic was interesting, but ultimately beside the point, because even an authentic trust document would not have transferred the house into the trust without the accompanying deed. She said the Montgomery County Recorder's records were unambiguous. She said the house was in Vera's name. She said it would be administered under the will. She said the will left it equally to the 4 nieces and nephews, and that was how it would be administered. She referred the matter to the Montgomery County Prosecutor's Office for review of the trust document circumstances. The house in Kettering sold 8 months after the ruling. The proceeds were divided into 4 equal shares according to the will. My share came to me as Vera had said at the dinner table it would, which is to say correctly and according to what she had intended and what she had documented with Cornelius and what she had kept in the drawer in the bedroom so that anyone who needed to find it could find it. I want to say something before I go. I want to say something about what you should do if you are in a situation where someone is claiming that a family member's real property was placed in a trust before they died. The first thing to do is search the county recorder's portal for the property. You can find the property by the owner's name or by the parcel number, which you can find in the county auditor's property search if you do not have it. When you pull up the deed history, look for a deed where the grantor and grantee are the same person, with the grantee identified in their capacity as trustee of a named trust. The deed will typically say something like, John Smith, to John Smith, trustee of the John Smith Living Trust. That form is the trust transfer deed. If you see it in the index, the property was transferred into the trust on the recording date shown. If you do not see it, the property was not in the trust regardless of what the trust document says. After you have checked the recorder's index, look for any estate planning documents the deceased might have kept, review letters from their attorney, their will, any notes about what they had and had not established. The combination of the missing deed and the documentary record of what was actually in place is the complete picture. The portal is free. The search takes 15 minutes. What you find or do not find is the answer. In Ohio real property law, the absence of the deed is conclusive. The recorder does not lose deeds. If it is not there, it was never filed. Also, if you find the trust document but no deed, the next step is to contact the attorney who drafted the will, if you can identify them, and ask whether they also prepared a trust. An estate attorney who has been working with a client for years will know whether a trust exists and whether the real property was transferred into it. They may also have a review letter or other contemporaneous documentation of what estate planning documents were in place at a specific point in time. The combination of the missing deed and the estate attorney's knowledge is the complete picture. In this case, both pointed the same direction. They almost always do. The recorder and the attorney together are very hard to contradict. Not about Brenda and not about the prosecutor, about the missing deed and about what its absence meant and why I looked for it specifically. When Brenda told me the house was in a trust, I understood that if this was true, there would have to be a deed. A trust does not own Ohio real property because a document says it does. A trust owns Ohio real property when the owner executes a deed transferring the property to the trust and records that deed with the county recorder. The deed is what transfers the ownership. The trust document describes the terms. The deed does the work. No deed, no transfer. When I searched the Montgomery County Recorder's portal and did not find the deed, I knew what the absence meant. The absence meant the house was still in Vera's name. It meant the house was part of the estate. It meant the will controlled. I had found this information in about 15 minutes on the county recorder's website. That information was the case. Thank you for staying until the end. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a man whose sister had been telling the family for 2 years that their mother's car had been titled to the sister before their mother died, and what the Ohio BMV title history showed about when the title was actually transferred and whether the mother had been alive on that date, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if someone tells you that a family member transferred their home into a trust before they died, the county recorder's portal will show you whether the deed that would have accomplished that transfer was ever recorded. The trust document is private. The deed is public. Search the name and look for a trust transfer deed. If it is not there, the house was never in the trust. The recorder's index does not lose deeds. If the deed is not there, the deed was never filed. If the deed was never filed, the property never transferred. That is the whole story. I want to tell you more about the morning I received Brenda's call and what the experience of searching the recorder's portal afterward felt like. I am a paralegal and I have worked with legal documents for 16 years, and I understand property records and deed indices, and I have searched recorders' portals in Montgomery County and other Ohio counties many times for work-related purposes. When Brenda told me the house was in a trust, I was not surprised by the claim, but I was immediately focused on the mechanism, because anyone who works with property law knows that the claim and the mechanism are two different things. The claim is that the house is in a trust. The mechanism is the deed that would have transferred it there. I said I would like to see the deed. She said it was private. I said deeds are not private. I said I will look it up myself. I searched the portal while we were still on the phone, with her on speaker, while she explained that trusts were private documents and not subject to public disclosure. I was not arguing about the trust document. I was looking for the deed. I did not find the deed. I hung up the phone. I called Marcus. Marcus had found the same absence. We called Cornelius's office before noon. I want to describe what the absence of a deed feels like when you know what you are looking at. It is not I want to say something about what the Montgomery County Recorder's portal looks like and what the experience of searching it for this purpose involves. Montgomery County is in southwest Ohio, and the county seat is Dayton, and the Recorder's office maintains public records of every instrument filed that affects the ownership or encumbrance of real property in the county. The online portal allows you to search by the owner's name or by the parcel number, and the results show the complete deed history for the property in chronological order, going back as far as the electronic records extend and often substantially further for properties that have been in families for a long time. The entries show the instrument type, the parties, the recording date, and the document reference that allows you to pull the actual instrument and read it. When I searched Vera's property, I read through 41 years of deed history in about 8 minutes. I was looking specifically for any deed where Vera appeared as both grantor and grantee, which is the form a trust transfer deed takes, with the grantee listed as the trustee of the named trust. There was no such deed. There was no instrument of any kind from the last 2 years of her life. The most recent entry was from 2009 when Harold died, and the survivorship affidavit was filed. The house had been in Vera's name alone since 2009, and it remained in Vera's name alone. The portal told me this in 8 minutes. I did not need an attorney to read it. I needed to know what to look for. I knew what to look for. I looked. The presence of contradictory evidence, which is what you find in a fraudulent deed situation where you can point to instruments that refute the claimed deed. It is the absence of anything at all. I searched the parcel number and I read through the complete deed history, and I reached the end of the index, and there was nothing. No trust transfer deed in any form. No instrument showing any change in ownership in the past 2 years. No document of any kind suggesting that Vera had taken any action with respect to the title to the house in the period when Brenda claimed the trust had been established. The last instrument in the index was a survivorship affidavit from 2009 when Harold died, and the property passed to Vera alone. After that, nothing. 41 years of the house being in the family and not a single deed change in the last 14 years of Vera's ownership, including the 2 years during which, according to Brenda, the most significant ownership change in the property's history had allegedly occurred. I also want to say something about what Cornelius Webb is like and about what it means to have spent 9 years as someone's estate attorney. Cornelius had an office on East 3rd Street in Dayton that he had occupied for 22 years, and that had the specific character of a professional space that has been organized according to the same logic for a long time, and that works because the logic is sound rather than because the furnishings are new. He had files going back to the early years of his practice in the cabinets along the east wall, and he knew where everything was without looking. He had Vera's file in his hands when I arrived because he had pulled it when I called, and he had read through it before I got there the same way he reads through a client file before any meeting, which is thoroughly and with the specific attention of someone who understands that the file is the history of a relationship and that the history matters. He had known Vera for 9 years. He had prepared her will. He had sent the review letter 1 year before she died. He had signed that letter, and she had kept it in the drawer. And the drawer was where she kept things she wanted to be findable, and she had told me the drawer was where I should look. I want to tell you about that drawer, and about the specific quality of finding Cornelius's letter in it. I had gone to the house 3 days after Vera died, before any of the family had discussed the estate formally, because I had wanted to make sure the house was secure, and because I had remembered what she had told me about the drawer. I went to the bedroom. I opened the drawer she had described. The will was there in a folder labeled Will with the year. The insurance was there. The financial summary was there. The estate planning folder was at the back of the drawer. I opened it. I found the letter from Cornelius. I read it. I read the line that said, "You have not established a living trust." I read the line that said, "Your real property is titled in your name individually." I read the date at the top of the letter, 1 year before her death. I stood in her bedroom with that letter, and I understood what I was holding. I did not know yet that I would need it. But I kept it because she had kept it, and because she had kept everything for a reason, and because I have spent 16 years working with legal documents, and I know which ones matter. I want to say something about living trusts and about the specific legal mechanism by which real property enters a trust in Ohio, because I think this is widely misunderstood, and the misunderstanding is what makes claims like Brenda's initially plausible to people who have not dealt with the state law directly. A revocable living trust is a legal document in which the trustor, the person creating the trust, designates how their assets will be managed during their lifetime and distributed after their death. It is a private document. It does not go through probate. This is one of the reasons people create them, to pass assets directly to beneficiaries without the delay and public nature of the probate process. But here is the critical element that many people do not know. The trust document itself does not transfer the ownership of assets into the trust. To transfer a piece of real property into a trust in Ohio, the owner must execute a deed, a new deed, conveying the property from themselves as an individual to themselves as the trustee of the trust. This deed must be signed and notarized and recorded with the county recorder of the county where the property is located. Without the deed, the property is not in the trust. The trust document can say whatever it says about the property. Without the deed, the property remains in the individual's name. The deed is what moves the property. The recorder is where you look to see if the deed was filed. If it is not there, the property did not move. I want to tell you about Kettering. I want to say something about the trust document that Brenda eventually produced and about why its authenticity was ultimately beside the point. Cornelius reviewed it carefully, and he noted in his reply to the court that it had not been drafted by his office or by any attorney who had worked with Vera in his knowledge. He noted the departure from the estate plan he had prepared with Vera, specifically the terms that would have left everything to a single beneficiary rather than equally to the 4 nieces and nephews named in her existing will. He noted that the 1 year before death review letter had made no mention of any trust and that Vera had not contacted his office about establishing one in the year between the letter and her death. But he also said, clearly and emphatically, that none of this was necessary to the resolution. He said the trust document could have been entirely authentic and it would still not have transferred the property. The Ohio law was the law. The law required a deed. The deed was not there. He said the trust document question was a question for the prosecutor. The property question was a question for the probate court. The probate court had the simpler question. It answered it correctly and quickly, and the answer was derived entirely from the county recorder's index. The index was sufficient. It is almost always sufficient. That is what it is there for, and about the specific quality of the neighborhood where the house is located. Kettering is a city in Montgomery County south of Dayton with the particular character of a mid-century suburb that has maintained itself with consistent investment over the decades, and that has the texture of a place where people have stayed. The east side of Kettering, where the house is, has streets that are wide enough and shaded enough, and where the houses are set back enough from the road to give the neighborhood the specific spaciousness of places that were planned with an understanding of how outdoor space functions. Vera had lived in that neighborhood for 41 years, and she knew it the way you know a place you have inhabited for 4 decades, which is by the specific detail of it, the neighbors by name and by the particular qualities of their presences, the rhythms of the street, the small changes that accumulate into the character of a place. She had been part of the character of that street for a long time. Her absence from it is something the street has had to adjust to. I want to say something about the 4 nieces and nephews and about what the process of going through this together was like. There were 4 of us, me, Marcus, and our cousins Denise and Tom. We had grown up in the extended family that Vera had worked to keep connected, which meant we had the shared experience of holiday gatherings and the specific knowledge of each other that comes from decades of proximity without daily intimacy. We had each received a version of Brenda's call. We had each been given the same information, which was that the trust existed and the house was in it, and that Brenda would be receiving it. None of us had been shown the trust document. None of us had been shown a deed. When Marcus called me the same day, I called him to tell me he had also searched the recorder's portal and found nothing. We understood simultaneously that we were dealing with the same absence. We called each other and we called Cornelius and we retained him together and we proceeded together, which is the correct way to proceed when four people share an equal interest in an outcome that requires unified action. There is something I want to say about the trust document that Brenda's attorney eventually produced. I have not described it in detail because the details of its contents were ultimately beside the point, as Judge Adaeze's ruling made clear. But I want to say something about the legal argument that Cornelius made in response to it, because I think the argument illuminates something important about how Ohio law treats the gap between intent and execution in real property matters. Cornelius said in his reply that trusts are instruments of intent. They describe what the trustor intends to do with their assets. But intent does not transfer Ohio real property. Execution transfers Ohio real property. The execution that transfers real property into a trust is the deed. Vera might have intended, if the trust document was authentic, to transfer the house into the trust. But intending to transfer property and transferring property are different things. The law requires the deed. The deed was not there. The intent, even if genuine, had not been executed. The house remained where it was. The law was clear about this. Cornelius cited it. The judge confirmed it. I also want to tell you about the conversation I had with Cornelius after the ruling was issued. I drove to his office, and we sat in the office with the files along the east wall, and he said he was glad it had been resolved. I want to say one final thing about Vera, and about what I believe she would have thought of how this was handled. She was a direct person, and she had a specific opinion about the management of family matters, which was that the correct approach was to be clear about what you wanted and to document it clearly, and to make the documentation findable so that the people who needed to act on it could find it and act on it. She had told us at the dinner table what she intended. She had told Cornelius what she intended and had it documented in her will. She had asked for the review letter and filed it in the tab and told me where the drawer was. She had done everything that the person who wants their intentions to be carried out correctly does. The four of us had done what she would have expected us to do, which was to look at the documents and understand what they said and bring them to the right professional and proceed correctly. She had spent her retirement years continuing to be the person who kept the family connected, and she had extended that effort into her estate planning by leaving things in a state where the family would know what to do. We knew what to do. We did it. The house came to us as she said it would. The records held what she had decided. The drawer had what it was supposed to have. She had organized the handoff. The handoff worked. That is the whole story. That is what she would have wanted, correctly, and that Vera would have expected it to be resolved correctly. He said Vera had been the kind of client who understood the difference between having a document and having things in order. He said when she came in for the review meeting a year before she died, she had asked him specifically whether there was anything in her estate plan that could be misunderstood or misapplied after she was gone. He said he had gone through everything with her and had confirmed that the will was clear and the property was properly titled and there was no ambiguity. He said she had listened to this and had nodded and had said, "Good, I do not want confusion." He said she had then asked him to send her the letter summarizing what they had confirmed, which was the letter I had found in the drawer. He said she had asked for it specifically because she wanted a written summary in her files. He said she had known that documents and files are how you prevent confusion after you are gone. He said she had been right. I said yes. I said I found it in the drawer where she said things would be. He said of course you did. He said she was very organized. I want to say something about the drawer and about what it says about who Vera was. 41 years in the same house, and the drawer in the bedroom was organized the same way in the last year of her life that I believe it had been organized for a long time. Current documents in current folders. Tabs labeled with what was inside. Nothing in the drawer that did not belong in the drawer. She had told me about it not because she was worried about the drawer, but because she was organized in the specific way of someone who has learned that the usefulness of a system depends on other people being able to use it when needed. The system was in her head, and it was also in the drawer, and she had told me where the drawer was so that the system could survive her. She had been a nurse for 35 years, and nurses understand that information needs to be transferable, that the notes you write are for the next shift as much as for yourself, that the system has to work even when you are not there to explain it. The drawer was organized for the next shift. I was the next shift. I found what I needed. I also want to tell you about what happened in the house in the weeks between the ruling and the sale. We had agreed, the four of us, to go through the house together before it was listed. We went on a Saturday in late November, 6 of us counting spouses, and spent most of the day in the house going through 41 years of Vera's things with the specific combination of efficiency and grief that this kind of work requires. The kitchen was the hardest room. The kitchen had been the room where she had done the work of being the person who kept things together, the room where she had made the food and the calls and the decisions, and the kitchen had the specific density of 41 years of someone's habits arranged in the space that had shaped those habits. We worked through it the way she would have wanted us to work through it, which is methodically and without waste and with attention to what was useful and what could be given and what had served its purpose. I took the filing cabinet, not the contents of the entire cabinet, but the drawer with the estate planning files, the one she had told me about, with the will and the insurance and the letter from Cornelius. Marcus took her nursing reference books, which she had kept current into her retirement because she said the knowledge was still useful. Denise took the birthday card collection from the box in the bedroom closet, 40 years of birthday cards organized by year and sender, which is the specific kind of organized sentimentality that tells you everything about a person. Tom took the kitchen dishes because he had always admired them, and because he was the one who had inherited the cooking interest from her side of the family. We divided what could be divided and donated what should be donated and left the house in the state in which it could be listed. The sale closed in February. The proceeds were divided 4 ways. The drawer is on my bookshelf. The letter is inside it. I want to say something about what it meant to me personally that Cornelius had sent that review letter. It was not a document I had asked for. It was not a document I had known existed before I found it in the drawer. It was a document that Vera had requested from Cornelius because she understood that the confirmation of what she had done and not done should be in writing and in her files and findable. She had requested it 1 year before she died, which means she had been thinking about what would need to be findable after she was gone, and she had taken the specific steps required to make the relevant things findable. The letter said, "No trust. The house is in your name. The will is current." That is what you need to know. She had it put in writing. She filed it in the tab. The tab was in the drawer. The drawer was where she told me things would be. The sequence worked because she had designed it to work. I also want to say something about the 4 of us and about what the experience of going through this together did for relationships that had the specific quality of extended family relationships, which is the quality of people who share history and affection without the daily proximity that would otherwise deepen the knowledge. We had all been brought into this situation by the same act and had each responded to it by doing the same thing, looking at the public record, comparing what we found, and calling each other. Marcus had found the same absence I had found and had called me before I called him. Denise had looked up the recorder's portal and had noted the absence before she heard from either of us. Tom had been skeptical of the claim from the start and had asked Brenda for the deed directly and been told the same thing we had been told. We were 4 people with the same information and the same interest, and we retained the same attorney, and we proceeded together. The experience of that coordination, of being the nieces and nephews Vera had always gathered at the table, and of managing together what needed to be managed, was the specific thing Vera would have expected of us. We did it. We were capable of it because she had spent decades making us capable of it. That is what it means to be the person who keeps a family together. The family learns to function as a family. It can do so even when you are not there to organize it. I want to say one final thing about Cornelius and about the quality of the work he did. He had known Vera for 9 years, and he had prepared her will and sent her the review letter, and he had done all of it correctly. When I called him on the Monday after Brenda's call, he had already pulled the file. He had already read through the documents. He had already formed a view of the situation. He said, "I am not surprised by this call." He said, "I want to be clear that what I prepared for Vera was a will, not a trust, and that her real property was not in any trust when she died." He said, "I will be glad to help you establish this." He said the missing deed is the central fact, and the recorder's records will confirm it. He had understood immediately what the central fact was, and he had been right about what the records would confirm, and he had been efficient about getting us to the right answer in the right time. He had been organized the way Vera had been organized, which is the way you are organized when you understand that a well-maintained file and a clearly documented client relationship are what protect the people who are depending on them after the relationship ends. Vera had chosen him carefully. He had been worth choosing.